Bring in Judge Napolitano, Fox News chief judicial analyst. I'd like you to talk about this issue of the court trying to sort out, on the one hand, this is a court, not the president, saying we're not persuaded by the president's argument that this is a national security issue of so much urgency that you need to take this step.
It's precisely the wrong thing for the court to do, Chris, when you have the following observations, which are beyond dispute. The Constitution assigns the decision-making for foreign policy exclusively to the president. Even Congress has a subordinate role, subordinated to confirming ambassadors and ratifying treaties and paying for the State Department. The president has a lot of tools that the Congress has given him. One of the tools is the statute that he read yesterday, which we've all been talking about, which was exercised by President Carter and by President Obama, a blanket ban on immigrants from given places. The statute specifically says the president on his own, by proclamation, meaning he doesn't have to consult with anybody else, can make this decision. The decision to ban is not reviewable. It's not justiciable. Judges are incapable of second-guessing the president on it. So for that reason, he may be thinking the Supreme Court is going to invalidate this. I don't know which way the Supreme Court's going to go, and I don't know which court he had in mind, but this is an intellectually dishonest piece of work that the Ninth Circuit has produced tonight, because it essentially consists of substituting the judgment of 3 judges for the President of the United States when the Constitution unambiguously gives this area of jurisdiction, foreign policy, exclusively to the president.
But Judge, let me ask you directly about what I was just talking about here with the panel. I can't remember all of the details, but there were several cases that went to the Supreme Court after 9/11 involving enhanced interrogation, involving
Yes.
Guantanamo, and in those cases, the Supreme Court said that that President Bush had overstepped his bounds, and that they, as the court, were saying that what he had done was illegal. Why is this different, not on the merits, but on a matter of principle?
Okay, great question, Chris. You are speaking of 6 cases in which the Bush administration was challenged by detainees at Guantanamo Bay. It lost 5 of the 6. The one was on an issue because it was filed in the wrong court. The 5 that it lost all had the same issue at their base, and that is, if the government seeks to exercise its powers extraterritorially, like in Cuba, does the Constitution follow the government? And in all 5 cases, by different majorities and for different reasons, the conclusion was the same. The Constitution follows the government. This is precisely a different reason. This is not whether or not the Constitution governs the government. This is whether or not judges can interfere with the execution of an area of the Constitution which unambiguously gives the authority exclusively to the president. That's why this is so profoundly wrong. Let me add another gloss to this as to how complex it truly is when the president says in his inimitable way, "See you in court." There are 47 lawsuits, each in a different United States district court. This one in Seattle is just one of them. The Chief Justice of the United States, who bears the same name as our colleague John Roberts, should consolidate all of these, and he can do that this evening, and very well say it's not going to be tried by Judge Robart in Seattle. It's going to be tried by Judge Ammon in Brooklyn, because she also issued a nationwide injunction. So we're really in untested, untried, virginal territory here with a highly politicized Circuit Court of Appeals that assumed the powers of the presidency by second-guessing him and overruling him.
Just briefly, Judge, if he were to do that, whether it's in the Seattle court or the Brooklyn court or whatever court, how long, if you're now dealing with the merits, not the question of a temporary restraining order, how long does a case like that take? I mean, we're talking weeks or even months, aren't we?
Well, they could do it in an expedited fashion, but you're talking the shortest it could be is a couple of weeks. But the first order of business is this temporary restraining order. Judge Robarts entered the restraining order after 15 minutes of oral argument with minimal documents in front of him, with federal prosecutors utterly unprepared. And I don't blame them. The Justice Department didn't have Attorney General Sessions running it. They couldn't even decide who was going to go into court for them. I honestly expected the Ninth Circuit to send it back to Judge Robarts and say, give us a better record. Hold a hearing on this. Instead, they, for different reasons, ratified what he did.
Judge Napolitano, will bring you in as we continue to try to figure out all of the legal and also obviously political ramifications